Now, the educative effect of the law was really driven home to me when I did get elected in 1994. You know, all politicians take an oath to uphold the Constitution, and I thought if I'm going to take an oath to uphold something, I ought to read it. So I pulled out the Tennessee Constitution, and I began to read it. And I got towards the end in Article 9, Section 2, and I read this statement that flabbergasted me. It says, "No person who denies the being of God or a future state of rewards and punishments shall hold any office in the civil department of this state." If any of you have parents who are a lawyer, ask them to bring home the Tennessee Constitution in the little green books, and the caption, the title will say, "No atheist to hold public office." In 1870, that was put in our Constitution. It's still there today, and that's what we believed. That in essence, if you did not believe that there was a God or there was some ultimate accountability beyond the ballot box, we do not want you to hold public office. And when I read that, my mind immediately flashed back to what I'd learned in law school. The United States Supreme Court, 78 years later, in 1948, issued an opinion in which they said this: the First Amendment rests on the premise, the foundational idea, that both religion and government can best work to achieve their lofty aims if each is left free from the other. Wow. How far have we come in 78 years, from 1870 to 1948, that we go from saying, if you do not believe in God, we don't want you to hold office, to saying, if you do believe in God, we don't want you to hold office. From saying you must believe in God to saying, if you do believe in God, you must at least be a practical atheist. From saying that the two must intersect to saying they cannot intersect or they don't work well.